You make promises all day, every day. Buying a coffee, updating an app on your phone. These feel like simple transactions, right? But they're actually legally binding agreements. So, what's the invisible rulebook that's running the show behind the scenes? Well, in this explainer, we're going to unpack exactly that: contract law. Come on, be honest. We've all been there. That massive wall of text pops up and you just want to get to whatever you're trying to do. So you click. But in that one tiny moment, you are stepping right into the vast world of contract law. So have you ever wondered what you actually just agreed to? To really get a grip on this, we're going to follow the entire life of a promise. First, we'll ask, what even is a contract? Then, what are the essential ingredients you need to cook one up? After that, we'll dive into this constant battle between freedom and fairness. We'll also find out what happens when a deal isn't quite what it seems. And finally, we'll look at the fallout when a promise gets broken. So, let's jump in. Okay, first up, what's the big deal with contract law anyway? What makes it so unique? Well, at its very heart, it's about you, creating your own rules. It's the power you have to set your own terms, your own obligations with another person or a company. To really see what makes contracts so special, let's put it side by side with something else. See, some laws, like the law of torts, they just impose duties on all of us. A great example is the duty not to harm other people. You don't get a choice in the matter. But contract law, it's the complete opposite. It is built from the ground up on obligations you voluntarily agree to take on. You literally become the lawmaker for your own private agreement. And this wasn't just some small legal tweak. It was a truly revolutionary idea. The famous historian Sir Henry Maine put it perfectly. He said society moved from status to contract. Just think about that for a second. For centuries, your life, your obligations, they were all defined by your birth, your status. Were you a lord, a serf? That decided everything. But contract law, well, it changed the whole game. It helped create a world where your future is defined not by who you are, but by the promises you choose to make. So how does a simple chat about a deal or a handshake transform into a promise that's actually enforceable by law? Well, it turns out there's a very specific recipe, and it requires 4 essential ingredients. And it's just like baking a cake. If you miss even one of these ingredients, the whole thing just falls apart. First, you need a clear offer and a clear acceptance of that offer. Second, you need consideration. That's just the legal speak for something of value being exchanged between the two of you. Third, and this is crucial, you both need the intention to create a legally serious deal, not just a casual promise. And finally, you need certainty. The terms can't be all fuzzy and vague. Now, here is a classic trip-up point, a really common point of confusion. You see a price tag on a shirt in a shop window. You might think, that's a legal offer. But it's not. Legally, it's called an invitation to treat. The shop is basically inviting you to come in and make an offer to buy the shirt at that price. It's only when you get to the checkout that the shop accepts your offer. It's a subtle difference for sure, but a legally crucial one. Right, let's talk about consideration again, that thing of value. And this is where the law has this really fascinating quirk. The value has to be sufficient, which just means it has to exist. It could be something totally symbolic, like a single peppercorn. But, and here's the kicker, it does not need to be adequate. That means it doesn't have to be a fair market price. Why is that? Well, because it's not the court's job to protect you from making a bad bargain. Their job is just to confirm that a bargain was made in the first place. And that leads us straight into this huge philosophical tug-of-war that's right at the heart of contract law. This ongoing battle between the ideal of total freedom to agree to anything versus the very real need for fairness and protection. If you rewind to the 19th century, this idea of freedom of contract was king. It was absolute. A deal was a deal, period, no matter how lopsided or unfair it was. But over time, the law had to wake up to a new reality. What happens when it's just one person going up against a giant corporation? The bargaining power is completely out of whack. And that's exactly why modern laws, like the Consumer Rights Act, have stepped in. They act as a shield for the person who holds less power in the deal. And let's be honest, this is the world we all live in now, right? Just think about your phone plan, or your gym membership, or that software you just installed. You didn't negotiate those terms. They were just handed to you as a take-it-or-leave-it deal. These are called standard form contracts, and they are precisely why modern consumer protection is so absolutely essential. So we've seen that contracts need all the right ingredients, and they need to think about that balance of power. But what if the deal itself is just, rotten from the start? What if it's built on a lie or on force? The law actually recognizes that even if all the pieces look like they're in place, some agreements just aren't real because true, genuine consent was never there to begin with. These are basically the contract deal breakers. Lawyers have a fancy name for them, vitiating factors, but they all boil down to the same thing. They void a contract because genuine consent was missing. So for instance, misrepresentation is when you were told a flat-out lie to get you to agree. A mistake is when both people are fundamentally confused about what they're agreeing to. And duress or undue influence, that's when you were forced or bullied or improperly pressured into signing. In any of these cases, the law just says, nope, that deal isn't real. And that brings us to the final chapter of our promises journey. The contract is valid, everything seems totally fine, and then one side just doesn't do what they promised to do. What happens now? This is what we call a breach of contract. And really, it's as simple as it sounds. One party had a job to do under the agreement, and without a good legal excuse, they just didn't do it. A builder promises to finish your kitchen by Friday, but on Wednesday, they just pack up their tools and walk off the job. Yep, that's a breach. So how does the law actually fix a broken promise? Well, the number one most common solution is damages. We're talking money. The goal of damages is to put you in the exact same financial position you would have been in if the contract had been followed through. Now, a much rarer solution is an order for specific performance. This is usually only for truly unique things like a one-of-a-kind painting or a specific piece of land where just getting money back isn't enough. In that case, the court can actually force the other party to do the specific thing they promised, like handing over that painting. And that brings us right back to where we started, but with a big final question. We began this journey with the idea of contract law as this ultimate expression of individual freedom. But as we've seen in a world that is now dominated by these standard take-it-or-leave-it terms and conditions that we all just click agree to without reading, is that freedom still a reality? Or has it become something of an illusion? That's definitely something to think about the next time you agree.